for allowing us to be here, and also thank you for your patience. Again, 1,000 pardons. So yeah, we'll try to run the presentation about an hour, so if anybody has to sneak out an hour from now, hopefully they will at least get all the highlights. We're willing to stay as late as we need to answer any follow-up questions. That said, if you have a question come to mind, don't hesitate to interrupt, and we can either deal with it right then and there, or push it to the end if that's more appropriate. But yeah, definitely, we welcome any questions or participation that anyone would like to contribute to this little presentation here. So, as Mike explained, we come from Irwin IP in Chicago. We really focus on intellectual property disputes of all types, primarily patents, but also lots of trademarks and copyrights and trade secret work as well. We do a lot of work to strategize with our clients how best to really maximize their business from an intellectual property perspective. The fact that many of you have small businesses means a lot of this strategization isn't going to be resulting in billion-dollar cases and whatnot, but that said, it can be just as important to your business to get things right out of the gate, right? An ounce of prevention can be much more valuable than a pound of cure. And so if you're just starting out your business, it's critical to make sure you're doing things the right way to prevent yourself or avoid running into problems down the road. We assist in all sorts of different aspects of intellectual property and related business services, and then we do focus on Chicago, but as Mike mentioned, we do have ties to South Bend as well. Shu, you want to briefly introduce yourself?
Yeah, hi everybody, my name is Shu Lee. I am a second-year attorney at Irwin IP. I primarily specialize in patent litigation, and I do a little bit with trademarks. But honestly, one of my favorite parts of this experience so far as I'm growing in my career is working with small business owners, trying to get up their feet as to what IP can do for them and how they can help save their IP too. And just fun facts about me: when I'm not doing the law, I love volunteering, being out in my community, and I'm a huge animal lover, so we're college in Chicago.
And then I'm a little bit more long in the tooth. I've been around for about 18 years doing this. I've done all sorts of different types of intellectual property in all sorts of different types of areas of technology. My first love is soccer, and I tolerate my family's cats. Disclaimer, being an attorney, always the disclaimer. Nothing you should take here is something that should be construed as actual legal advice. We don't have a formal attorney-client relationship with any of you, and so none of this should be, taken as gospel. Every issue is very fact-sensitive, and so while what we say is hopefully something that can be broadly applicable to most or all of your situations, any given situation has to really be dealt with on a one-off situation where all of the facts are considered before actual formal legal advice is given. So yeah, take everything we say with a grain of salt. The agenda. We'll quickly go through kind of a high-level overview of intellectual property. What exactly is it? What are the different types of intellectual property? Then we'll walk through what we think are probably the two most important types of intellectual property for you guys as business owners and entrepreneurs. That's trademarks and copyrights. Then we'll briefly hit on some other IP issues, and AI is everywhere these days, so we'll also do a quick little bit on AI. And then talk about some additional resources that you can look for going forward.
All right, great. So we're going to start with what is IP. We have a couple of categories here. So the first two are what we're mainly going to focus on really tonight for the trademarks and copyrights, just because those tend to be good starter IPs for small businesses. And then we'll also talk a little bit about patents, trade secrets as well in our business hypos that we'll bring up later. But these are kind of the big categories for IP. So trademarks are more those logos, words, slogans that identify and distinguish your business from others. So some examples include like Apple, Starbucks, Ford, Pepsi, all those like logos are also those words. In addition, copyrights are more so original expressions that are in a fixed, tangible format. So what does that mean? That's films, videos, music, photos, things that are captured that you can have tangibly. And that could be lyrics, music, Broadway plays, all that type of stuff. As I mentioned, there's also patents. So there's different types of patents. Those are more focused on your inventions, your methods, your test ideas. And then there's trade secrets, which is technical information and commercial information. So those are your recipes, your marketing strategies, your algorithms. So why is IP important? There's a lot of businesses that have IP, and they also generate a lot of business and revenue from it. And so one of our partners had mentioned this, like historically back in the day with companies being valued of physical assets of 80% to now, nowadays it's kind of flipped. Now it's more so a lot of people have 80% IP rather than the actual physical assets themselves. We also noticed that a lot of the companies that recognize and leverage their IP have a higher growth, are likely more to export their products, and then are more probable to seek and obtain financing, which is super, super good. So just from that broad introduction of IP, you can kind of tell that IP is everywhere. So from the copyright of the photo itself, it could be confidential information or financial information. It could be just the trademark of that water bottle logo. And you can see that it's in everyday life here.
So does this include like a tagline?
So the slogan could be like the trademark of it, right? Like, it's great, like from Tiger Cereal.
Just do it.
Yeah, just do it. So like slogans like that are under the trademark feature of it. Yep.
So if I have a tagline like, "We really move our tail for you," I can get protection for that because it's intellectual property. It's something I came up with that is intangible but has value.
Right, and I think it also depends on what the depth of that slogan is, right? So if it's just like maybe one word, it might not be protectable, right? Because it's so commonly used. But if it's like that example that you just gave, Mike, where it's a little bit longer and it's a little bit more specific, then you can go out and protect it. Going back to that, we can also talk a little bit. There's other as you mentioned, designs, you mentioned slogans. Sounds can be like that. For instance, like Netflix's like ba-dum sound, that's also trademarked, right? And there's also scents. So like for instance, Play-Doh has that like vanilla cherry scent that they have trademarked. There's also colors like the John Deere green or the Cadbury purple that can be, Tiffany blue. Those are all examples of trademarks. So that's why it seems like trademarks and copyrights are a little bit more applicable to small businesses because you can specifically and easily get that from IP. So we're going to play a little game just to get everybody a little bit active. Even though we've been talking a lot about it, we want to make sure you have a good understanding. So we just wanted to ask what type of IP is below, and can you guess what companies they are? So feel free to raise your hand if you feel brave and courageous out here. Otherwise, you can write it down. And a bonus question is, in your own companies, what type of IP do you have?
I do one. Spotify.
Awesome, that's number one.
Do you know what kind of IP it is?
Is it a trademark?
Yeah,
Yes.
you got it.
Very good.
No, I mean, we can, yeah.
Number 2, oh wait.
No, man, come on.
Yeah.
That's smile.
Amazon Smile.
Amazon Smile.
Exactly
Anybody
right.
else for the rest of them?
I'll do 5, is that Delta?
Yep, Delta Airlines, correct?
That's no trademark.
Yep.
And number 2, Amazon.
Yep.
And number 6, Happy Feet.
Penguin
Penguin Publishing.
Yeah, good job, awesome.
Somebody say 3 already?
Nope.
Chicago Bears.
That's
Yep.
right.
Anybody know 4?
Is it candy?
Panda Express.
No, I didn't think about that though.
It ain't come from Canada.
Yeah,
Last one.
no. Anyone?
Candy.
International organization that you got most?
Yeah, it's a World
Exactly.
Wildlife Fund. Yep, exactly. So good job there. Anybody else have ideas about, for their own business, what kind of IP that they might have? Anybody want to share?
My logos, Mike mentioned our slogans, so I have that. And then my education, because I'm building an education program, so all the, my wording and the book that I'm producing for the class, all that's copyrighted.
Good job, that's
Exactly
awesome.
right.
Yeah, that was the
Very
first
good.
off the bat. Anyone else want to share?
Because all of you have intellectual property.
Yeah.
Well, we have a slogan, but also I feel like we have a sound because it's in the crunch when we eat our chip with our pico. So that kind of is like, we wait to hear that.
Yeah.
Oh yeah, and they do a head nod, so it's kind of like a visual. I don't know.
Not to put you on the spot, can you do it? Is it like a, yeah, the crunch of the nod, or?
So it goes like.
There
We have a unique logo for our company now. The fact that we do video, audio, do audio productions, write copies for commercials and things like that, how does that play into, I mean, I'm sure you'll get to some of that later and ask some questions, but I know some of those things that you listed can be
Protected.
can be protected, but when we're doing work for other clients, that there, I guess there's a line there that sometimes
Yeah.
that I'm not sure exactly how to broach sometimes.
Yeah, I think that's considered kind of like a work for hire, so it's kind of what you mentioned in terms of maybe you're working and producing that IP for somebody else. And so that can kind of get into more of the contract or like assignment land of making sure like there's a clear written understanding of who owns the IP, right? Did you sign it when you were employed to do so, like under that institution or that entity? They might own it based on that, contract that you've signed. But it's always a good way to have that discussion between you and the other individual that's owning the IP.
Yeah, and if your products are intellectual property related, for example, if you are creating copyrighted materials, if you're making designs or sculptures or something like that for a third party, in those instances, getting good legal representation can be of paramount importance, because depending on how that relationship is structured and whether magic language is used in the contract or not, can determine who owns ultimately that work, right? So if you make this statue for someone, or if you write a manual for someone, that's copyrighted information, that's copyrightable information. But if you do that under certain terms, it can be that you are giving them the right to use it, but you retain ownership of it. So if you want to then go down the street and let someone else use it, they can. Or on the flip side, if the language is right or wrong, depending on your perspective, it can be that you're giving them all rights and interests in that sculpture that you just made, and now even though you put your blood, sweat, and tears into it, they are the ones that own it. You are not allowed to make a replica of that, even though it's your sculpture. They're the ones that determine who else in the entire world can ever use that sculpture or have a replica of that sculpture. So yeah, if you're in the business of intellectual property, then it becomes even more important, of paramount importance, to make sure you're understanding the relationships that you're entering into and whose rights flow to whom in that transfer of service.
So anticipate, I think what I just heard is the necessity to anticipate on the front end who's going to own the intellectual property.
Yes.
And can one develop a standard form for that?
Yeah, absolutely.
I'm in a situation where we've had interns and we're right in the midst of, we probably have a marketable product. What do we do to take it to production?
Yeah, if you're talking about,
Here's the question back here.
Oh, I'm sorry.
yeah, so the question is, for example, if you have interns, if you have employees who are writing a software program for you or something like that, right? Writing some sort of language in a manual or writing some sort of serviceable product, whatever it may be. Who owns that, right? does the employee, the intern who wrote that, do they own that, or does the company own that? And again, it depends on the way that that relationship is structured legally. And hopefully, you have an employment contract with your employees or with your interns that makes sure that all rights and all intellectual property that they develop while they're working for you flow to and are automatically assigned to the company itself. But that's not necessarily the case, right? If you've never actually entered into a formal employment relationship with someone and it's just paying them under the table, then it can be that the default ownership might be to them, right? And in that case, now you're going to have to try to either hope and pray that it doesn't blow up in your face, or come back to them now in the 11th hour and say, hey, all of that work you've already done, now you need to assign that to us because you were supposed to have assigned it to us, but we didn't make you do it at the front end, and now they're in the driver's seat, right? Now they own the rights, and you're asking them to give them to you. And so, you know, they have you kind of over a barrel. And they're like, I'll do that, but now you're going to have to pay me an extra whatever money, right? So that's why it can be very important to get things right on the front end, so you don't have to try to fix things on the back end.
And as Reed mentioned, that's more so like perhaps having like an employment contract of some sort, having some provision there that talks about the specific rights and who owns them. And then it can also be bolstered by having maybe an employee handbook or some sort of policy that says this is how IP is handled, depending on how you work on it and what the relationship is. So those are ways you can tackle those situations.
We did not know that.
We're gonna run out of time, don't keep moving here.
Yep.
Sounds good. So these are just kind of the benefits of IP. We were just going to say, you know, it makes your brand distinctive. It also attracts loyalty for your consumers, making sure that, you know, they identify your brand and can associate positive experiences with it. Competition and commercialization. Competition is more for patents, so you can encourage innovation by having cross-licensing, or you can also block competitors from creating that type of invention in the first place too. Commercialization is more so having direct sales of your goods. You can also indirectly, you know, have revenue from licensing and franchising, and then you can also secure financing. And what that means is we kind of put the Ford logo, for instance. At one time, Ford went into some sort of bankruptcy, and they actually used their logo as collateral, so it had monetary value for them in that type of transaction there. So we'll kind of go into trademarks. I know we've talked a little bit about it, but Reed will go through the definitions and also how to apply for one as well.
Yeah, so when you're thinking about these different types of intellectual property, oftentimes it's helpful to kind of look at them from a policy perspective, right? Why are these rights even around, right? And in that regard, trademarks are kind of a black sheep in the IP family. Copyrights, they're there to ensure that the person who, you know, created something can reap the benefit of that thing, right? Patents, similarly, whoever invented this new gizmo, widget, whatever, should be able to, you know, capitalize on that ingenuity. Trademarks are more outward facing, right? Trademarks aren't there to bring value to the owner of the trademark, though they invariably do if you have a successful business. But the fundamental reason for trademarks is to protect the consumer, right? If you go to the store and you see a can that says Coke on it, you want to be able to trust that, hey, I know what a Coke tastes like. If I buy this can that says Coke on it, when I crack it and drink it, I know I'm going to be getting Coke, not some who knows what from who knows where containing who knows what ingredients, right? And so the basic premise of a trademark is trademarks are there to allow customers to understand who they're buying from so that they can rely on an understanding of what that means to buy from that particular person or that particular company. Now, trademarks come in a variety of strengths and types. First of all, there are registered and unregistered trademarks. Anybody who starts a business and, you know, hangs up a sign that says, you know, Joe's whatever, that can be a trademark, but it really gains strength when you register that mark, because there are certain rights associated with the registration process because it's through that registration that you put everyone else on notice that, hey, you know, I'm doing this business and I am doing it under this name, and so nobody else is allowed to do that, right? If you're just doing it, then you have rights, but they're much, much more limited because you haven't announced to the world, this is who I am and this is what I represent. Now, when you're choosing a trademark, for example, the name of a company, right, the name of a business, there are a variety of types of trademarks, classes of trademarks. The worst thing to do is to pick a name that's completely generic, because you can't even get a trademark on that. That would be, for example, if you're starting a grocery store and you decide to name your grocery store supermarket, right? You can't get a trademark on supermarket because that's just what it is, and that's what every other supermarket is. It's a supermarket. So you have zero rights if you name yourself supermarket. Marginally better would be descriptive. So, for example, your chips, right? You decide, I've got a great name for my chips. I'm going to call them Crunchy.
Chips.
The name of my chips is Crunchy, right? Well, all chips are supposed to be crunchy, right? So you're just describing a characteristic of your product. And while that can have rights associated with it, they're very difficult to get, because the presumption is everything's going to be crunchy if you're in the chip marketplace, and so you should not have a right to exclude others from using the adjective crunchy to describe their stuff too. So you can get secondary meaning, for example, if you have the name Crunchy for 50 years, maybe it will become synonymous with your chip, right? But it's a very, very difficult thing to get full rights in a descriptive mark. One step up, suggestive. This is a little bit more removed. This would be, for example, Jaguar, right? Jaguars are not cars, Jaguars are animals. But when you think Jaguar, you think fast, nimble, sexy, right? And so a sports car manufacturer would want those types of attributes associated with their car. And so suggestive, it's more abstract than mere descriptiveness, but it's still kind of along that same vein of, you know, it's evoking something common or similar to what you would want associated with your product. Finally, the very strongest is fanciful and arbitrary. For example, computers and apples. You know, there's really nothing to relate computers and apples together. So Apple is a very fanciful or arbitrary term to associate it with electronic products. Something completely, you know, some Spotify, right? What even is a Spotify? That term didn't exist before Spotify became a streaming service. So that is a fanciful term that didn't exist until they brought it into existence and labeled it with their product. So those are the very, very strongest types of marks that you can use, something that's fanciful or arbitrary. So if you're trying to come up with a name for your business, trying to come up with a name for your product, have this in mind, right? The more fanciful, the more arbitrary, perhaps the harder it will be to get initial traction. But in the long run, if you have a quality product, that is going to make yourself much, much stronger in the marketplace and much easier to protect your position once you find some success. So how do trademarks work? We went over this quickly. It really functions as a source identifier. And so skipping down here, the policy consideration is we don't want to confuse the public. If someone starts using your mark, or if you start using a mark that's similar to someone else's mark, that will cause confusion, and that's why trademark infringement is a thing to worry about. This over here on the top is a Birkin bag. The ladies probably know what a Birkin bag is. Not sure if the guys know what a Birkin bag is. But below is an NFT. I don't know if you guys remember NFTs from 7 or 8 years ago. NFTs are not handbags, right? So you would think, well, wait, the whole point is to avoid confusing the public, right? And nobody is going to confuse an NFT, a little thumbnail, with an actual Birkin bag itself. But in addition to confusing the public, there are ancillary rights, and which one of those is trademark dilution. And here, basically, they're saying you can't really glom on to someone else's success and ride their coattails, right? So if it's not Birkin that's creating these NFTs of Birkin bags, you're basically diluting their mark because you're basically riding the coattails of Birkin when you're using their product to make a completely unrelated product, but using their name to find success in that unrelated field. A few instructive cases. One case, Starbucks v. Charbucks. Basically here, there was a small company that made one of their blends and called it Charbucks. Now the interesting thing here is that this was a claim of dilution and blurring by Starbucks, and they ultimately lost, right? Charbucks won. But, and the reason why is they're only talking about a blend, right? So if you go into Black Bear Coffee Company and you say, I want a Charbucks, the court decided, you know what? It sounds a lot like Starbucks, but nobody's gonna go into Black Bear Coffee Company and think that this one single blend of coffee is a Starbucks blend of coffee in an entirely third-party situation. So they won, but I think the takeaway here is to realize that large companies can be very, very protective. Again, going back to the rule of thumb, back in the olden days, IP may be accounted for 20% of a company's value. Frequently nowadays, it can be a majority of the company's value. So they are extremely litigious when it comes to protecting their space. And so if you are starting up a Black Bear Coffee Company, and you're trying to decide what to name a blend, you could name it Charbucks. But you have to remember, or who knows, some other, Dunkin' Delight, something like that. And you can look at this case and think, there is a high probability I will win. But you also should think, do I want to risk getting sued? Right? Because is the value in naming it something that kind of is evocative of Dunkin' or Starbucks worth the risk of $1 million lawsuit, right? You win, but at what cost? So that's kind of one takeaway to think about here is sometimes it's better to avoid the fight than to invite the fight. Another case, Monster Energy versus Monster Fish Keepers. Monster Fish Keepers was just some small hobbyist about fishing, and he made some t-shirts to defray the cost of running his website. He got sued. Again, he won because energy drinks and a fishing hobbyist are two very, very different things. But again, the question is it worth the fight? And so it's sometimes best to, when you're trying to decide what to name something, what your product should be named, what your company should be named, it's good to be right, but sometimes when you're on a shoestring budget, it's even better to be safe. The world is your oyster, so maybe avoid an already claimed oyster. Similarly, this Jack Daniels versus Bad Spaniels. This was a Supreme Court case about a year and a half ago, and here, basically, the finding was, it was claimed to be First Amendment, right? I have a right to name something Bad Spaniel. It's a chew toy that's kind of a spoof on Jack Daniels, and basically, the Supreme Court said the right to express yourself does not relieve you of your obligations to abide by anti-dilution rules and laws, and also it does not shield you from protection if you're primarily doing what you're doing for a commercial purpose, right? If you're doing it for speech purposes, that's one thing. If you're doing it for commercial purposes, that's something entirely different. So again, takeaway is be careful when you're coming up to the line against someone who's established, especially someone who's established and has lots of money to spend on $1,000 an hour attorneys. Tread carefully. Common mistakes.
So I could have a business and call it Uber because it's Uber popcorn.
Yeah, yep. Yeah, you could name your popcorn company Uber Popcorn, and it might be a great name, but just know that you're much more likely to get sued by Uber if you name it Uber Popcorn than if you name it Gobbledygoo Popcorn, right? And so the question is the juice worth the squeeze, right? And that's something that you have to take into account. Maybe Uber is the perfect name and you're willing to run that risk, but realize that there is a risk. Some common trademark mistakes, just right out of the box, like I said, choosing a generic or destructive mark that just doesn't give you the protection that you need and allows others to come in and say something very, very similar, and you're just basically left with no right to stop them from treading on your territory. Not doing a clearance search. Again, choosing Uber Popcorn as the name, not realizing that there's a massive multi-billion-dollar company called Uber that is likely to sue your butt when you do that. Incorrectly or using or leaving off the trademark, subject, service mark, registered markers, basically not claiming your trademark, not using the mark properly in commerce, failing to police your marks, right? You can have a trademark, but if you're letting other people use that mark and you're not telling them to cut it out, you can lose that right?
Hard. So if you're already trademarked, should you put that next to your logo and your company name every time you use it?
Best practice would be yes.
Okay.
Yeah.
And I
Yep.
also wanted to jump in for the clearance searches. That can be as simple as just Googling, right? So if you have an idea of a name in mind, you can just Google it, see what kind of other companies are already out there that are using it. Or you can also go to the USPTO's like trademark search website as well, and they'll have a database as to who has already federally registered their trademark. So you can take a look at yours, you can take a look at theirs, and see if there are any other competitors. And that's an easy way of saving yourself, tons of money from being sued from these bigger companies, right?
In accordance with what you just said, is it true that if you put the copyright and trademark next to your logo while your federal thing is being processed, is it still protected?
It depends.
Because I've heard
Any good attorney will answer you with it depends.
I've heard both sides, yes.
Yeah. So yeah, there are different types of actually trademark applications. There's a use-based trademark and an intent to use trademark. If you are using your trademark nationally across state lines, then you become eligible, and that can be as simple as just having a website, right? Because a website's going to be available everywhere. So if you have a website, or if you're selling products in Illinois and you're living here in Indiana, you're going to be eligible to seek federal trademark protection. And that is definitely, in terms of bang for your buck, if you're going to register your trademark, you'll definitely want to get a federal registration if you can. You can register them with the register your marks with states, but by far and away, a federal mark is what you want if you can get it. And if you have a mark that you're already using, you can do a use-based mark, which is a little bit easier. But if you have a great name and you want to protect it, you can file an intent to use mark. And that says, look, I don't have a product yet, but I got this great idea for a name and I don't want anybody stealing it. So I'm going to file this now, and it gives you, I think it's like 6 months or something, and then you can add extensions if you need to. But yeah, that says I'm going to be using this shortly, so I'm sticking my stake in the sand and claiming my territory right now. If you're already using it and you have not yet applied for a trademark, which is kind of the opposite of intent to use, you're already using it and now you just want to register it now, you have certain common law rights in trademarks that you're just using, right? You have some inherent rights, because again, the whole point of this is to protect the consumer. And so if you're using your mark, you have certain rights in that mark, whether it's registered or not. It's just that they're very limited in relative to a fully registered federal mark. And that goes both ways, right? If you're using the mark and somebody else 2 towns over is also using the mark, and then you get a federal registration, your registration doesn't obliterate the rights that they have in their mark. And so if you have Uber Popcorn here and somebody in Fort Wayne has an Uber Popcorn, you get yours federally registered, it may be that you can market your Uber Popcorn anywhere in the United States except for Fort Wayne. Because that person has been operating as Uber Popcorn for 10 years in Fort Wayne. And everybody in Fort Wayne, when they think Uber Popcorn, they think that's Jim down the street's popcorn company. And so now even though you have a federal mark, it may be that there's a common law carve-out that prevents you from having global rights in it because pre-existing marks can take priority over that registration.
But those pre-existing can't expand because you've expanded everywhere else except for where.
But those pre-existing marks will be limited in territory to a reasonable zone of expansion. So it may be Fort Wayne and the immediate suburbs around it, but they will be limited to that forever after unless you abandon your mark down the road.
Can you get a hold on, I'm sorry, can you get a hold on the trademark perhaps if you maybe you put a hold on it while you maybe get the money to pay for it?
Yeah, so that would be like the intent to use application.
And
So
that works for the use base as well?
use base is if you're already if you already have that trademark in application. So say you're using that trademark on your products and your goods already, that's the application you go to. If you haven't gotten that trademark yet, or you're still coming up with a business name, that's the intent to use. So I'm intending to use that trademark to sell my goods and sell my services soon. I'm just telling the USPTO, that's my name, I want to have a stake on that. And then, as I'm developing within that 6 months, maybe my website, or maybe that's my product, that's when you're showing evidence of, hey, I'm actually using my trademark, now we're ready to go. So that's the one that you want to use.
And all of that can be done online through the USPTO site?
Yeah,
Yep,
exactly.
yep. Did someone else have a question?
If I can remember it. My question is, who does the attorney, you have to have an attorney to establish the whole thing, correct? To finalize it?
You can do it pro se, is what they call it,
Yeah.
without the help of an attorney. And some people, I will say, if you're going to do something pro se, I would much rather you try to do a trademark pro se than you do a patent pro se. But that said, even a trademark, as simple as a trademark application is, this shows you the typical process. Right? If you're lucky, you do this path, which is you file it and they say, that's cool, you're done.
Right.
The vast majority does this slightly more involved process, where you'll send it in and the examiner, the person at the government will say, yeah, I got your application, but I have these concerns. You need to limit it this way. This isn't clear to me. What do you mean by this? Why are you saying this? Why are you claiming this scope? And if you were doing it on your own, you might be lucky enough to do it perfectly right, but there's an equal chance that you say something that you don't realize has much greater, dangerous, problematic it has far greater implications than you are giving it in a legal context. So yeah, you can do it on your own, and it may work out great for you. But if you try to do it on your own, there's also a chance that it will go horribly wrong, and then you'll have big problems.
So like for Nike, I don't even know how to say it actually.
Yeah.
But they would trademark there would be separate trademarks for each of those? Like
Yeah.
Just Do It?
Exactly.
Right.
Yeah, they'll have a trademark for
The swoosh?
the name Nike. They'll have a trademark for the stylized font name Nike. They'll have it for the swoosh. They'll have it for Just Do It.
So it can get expensive.
Yeah. That said, like I said, these are relatively cheap. A trademark, if you're doing it on your own and you don't have any legal help, it's just a few $100. But yeah, if you have an attorney doing it, it can probably range to a couple of $1,000s probably, which is still, legally speaking, pretty cheap. But for a strapped shoestring entrepreneur, $2,000-3,000 can be a whole lot of money. So yeah, that can be the difficulty. A few quick business hypotheticals. If there's a similar name, competing kettle corn business across the state line, what do you do? Again, I think we already talked about this. If you file for a federal mark, you'll have, and you get it, you'll have national protection, but that other business may have a local right to use that name as well if they pre-exist your application. Example 2, what if the owner of an electric scooter company finds out their logo is similar to another on the market? Again, this kind of goes to some of those examples of the cases, right? Is this other company a well-funded company that can throw hundreds of thousands of dollars of legal attorneys at you in a litigation? If so, it may be best to cut your losses, rebrand before your name gets out too far, or if it's another startup who's just as broke as you are, maybe you just try to, outcompete if you love your name and you can get that trademark. It may be that you can beat them to it. So there are strategic considerations to take into account there. But yeah, there are definitely things that can be done, definitely things that definitely should be thought about if you come up against someone who is similar to you in terms of their trademark and their branding. Final example, are there any protective measures when a competing personal care business owner takes pictures of another store, its items, and copies the marketing in a similar fashion for their own business? This is an interesting one because this actually has trademark and copyright implications here. The trademark, as we talked about, come in all sorts of different shapes and sizes and types. Smells, sounds, words, phrases, fonts, those types of things. Also, there can be something called trade dress. A trademark is a name. A trade dress can be something like, the look of your store, right? If the style of your store is distinctive, you can claim that as a trade dress. And so if someone is coming in and says, I love the way that they've, decorated their store, and they have 3 stores and they all look exactly this way, I'm going to do that too. There's a very good chance that you could claim that they are infringing on your trade dress. But also if they're stealing your marketing, right? If you have beautiful signs and language and pitch materials, it could be that they're also infringing your copyrights that way.
All right.
So I have a question. I hope it's relevant to folks, but because my bias is that nothing about you guys or against you at all, but lawyers scare people into spending money that they don't have to spend. And a good example is in the state of Indiana, you can go online and register a single member LLC for $95, and yet we have people in this room that have paid $2,000 for a lawyer to do just that. And so my question is, if I'm an entrepreneur, so we have an entrepreneur in a program who sells hats.
Yeah.
And her business is called Laconic Blue. So the name has nothing to do with hats.
Right.
My question is, how could she go wrong if she just went online and filed her own trademark? If her intention is to sell her hats in a 50-mile radius of Southbridge.
Well, first of all, if it's a 50-mile radius, I guess that might capture bits of Illinois. If it's only within one state, then you're only going to have, the whole point of getting a federal mark is interstate commerce, right? So if you're only selling within one state, you really don't have the option to have a federal mark, even if you wanted one. But so first of all, if that's the case, then yeah, she doesn't even need to worry about the whole rigmarole of the burden of a federal mark, and you can just register it with the Indiana Secretary of State, presumably, and that's much simpler, and most states that's a trivial process. And so yeah, if you're only looking to sell locally, then you can not worry about a lot of this complexity. If you are trying to go internationally or nationally, I should say, if you're looking to go nationally, and yeah, your name is Laconic Blue or whatever it is, for example, if you send that in, what could happen? Well, like I said, best case scenario, they say, perfect, nothing to do with hats, you got it, you're done. You're off and running. Great, perfect. But what happens if there's another company called Iconic Blue? Now they're gonna say, wait a second, Laconic Blue and Iconic Blue, those are very similar in the way they sound, so, and you're gonna get an office action is what they're called, and they're gonna be pushing back and say, I don't think you're entitled to it. And now she has to either try to figure out how would an attorney argue to this government attorney that no, they're actually different enough that I should be able to keep my rights, or you just throw up your hands and give up and say, okay, never mind, I'll just stick with my common law trademark. Or it could be that they come back with a different office action and say, Laconic is fanciful and arbitrary, but blue is descriptive, right? There are blue hats. So you're gonna have to disclaim blue, and you can only register Laconic Blue as a joint term, and you have to disclaim, the blue portion of it, and you can only use it as that full phrase. Well, okay, again, you have to either decide, how am I gonna argue that as an attorney, even though I'm not an attorney, in a way that this government attorney is gonna buy what I'm saying, or do I just have to concede it and say, okay, fine, whatever you say, I'll take whatever you're gonna give me, and I'll run with that. So those are just a couple of examples of where it could sail through beautifully, but it could very easily come back with one of any number of objections, and now all of a sudden you have to say, okay, what in the world does this objection even mean legally for me? Is it something that I need to worry about, or is it something that it's like, fine, we'll accept your objection because it's substantively not going to impact your rights in any way, so we'll just go with it. And that's the type of work that an attorney who's done it for 20 years will very easily be able to say, I know exactly how to argue this, or it's not even worth arguing. So that's the kind of situation where it would be very helpful, potentially, to have an attorney in your corner.
And how can I know whether I'm paying the attorney a fair price or I'm getting ripped off?
That is a good question.
I think that also goes into like, you don't, if you talk to an attorney, right, you can also talk to other folks, right? Typically with attorneys, they also offer these free consultations so that you can kind of tell them about your issues. And that also can give you a vibe as to, do I like this attorney? Do they understand my issues? What's their working style? How much are they, willing to give me for the advice first before I have to pay up? Those are all factors that you can take into account. I know, Mike, that one of your concerns was just kind of the financial aspects of it, right? So, you can seek attorneys through perhaps like the Indiana Legal Aid Society. There's also bar associations that'll also do these on pro bono basis as well, where you're only paying for filing fees. So we have in our firm a pro bono business where we are helping small business owners like yourselves just with filing trademarks. So we're doing all the work, they just have to pay the filing fee to the USPTO. We're not getting any of that, right? So there's pro bono programs, bar associations, law schools around here, for instance, like Notre Dame, and I'm sure IU McKinney or Bloomington also have student clinicians as well, where you can work with students to say, hey, this is my trademark, hey, this is my copyright, can you file this for me? And that's part of their coursework, right? So they're getting credit, you're also getting it for free. It's a win-win situation.
Yeah, there's a chance that you can get free legal service. They're definitely, all attorneys are encouraged to give back via pro bono service.
The one thing too, when I looked at filing for a trademark, if it gets rejected or doesn't go through, you have to pay again.
Yeah.
So that is a big deal, right? If I pay a lawyer who knows how to do it, I have the confidence that I'm not going to have to keep paying over and over to learn how to do it.
And you're
Right.
also going to learn a little bit more about the requirements, right? Not only after you file a trademark application, you have to file a renewal application as well. So if you didn't know you had to file a renewal application between your 5th and 6th year and your 9th and 10th year, you're going to lose that. And then you have to start the process all over again, right? So the benefit of hiring a lawyer at least is they'll give you the upfront. We're risk averse, right? So we have to give you the upfront as to, hey, by the way, here are your timelines. Make sure you're paying these. Make sure you're staying on top of it. Or, hey, also make sure you're registering them. Or even with the LLC, right? Like if you don't have an LLC and you're perhaps starting out as a business owner, exactly what you said. Make sure you go to your Secretary of State, start filing that, get your EIN number, check out your local counties, what type of taxes you have to pay, all that stuff. So attorneys will at least give you all of those different possibilities, and you can work with them as to narrowing down the scope, right? That's also how you kind of cut down cost of, hey, I'm just focused on this, tell me about this.
But yeah, even if you don't have the luxury of a pro bono or a nonprofit or a clinic that's doing it for free or a very reduced rate, if you are going to pay full freight, going back to that disclaimer, right? They aren't going to do any work for you until you formally retain them as an attorney so that there's that attorney-client relationship. And before that relationship gets consummated, executed via some sort of agreement, you know, they're always going to have a sit down to understand your case, to understand whether it's a case they want to take on, that they're comfortable taking on, whether there's conflicts, you know, whether, you know, working for you is going to cause a problem with some existing client they've already got. So no matter what happens, they're always going to have an initial consultation with you, and that should absolutely also incur or involve a discussion of what the job is going to be and what that's going to cost. And yeah, I would always recommend you talk to at least 2, maybe 3 or 4 attorneys. And if one of them is saying they're going to do it for 20 grand and the other 2 are going to say 2,500, clearly you don't go with that first guy unless you really, really love him. But also, you know, there may be a case where you would want to go with that guy because it could be that those other 2 guys are hiding costs, right? They're like, it's only going to cost 2,500, but they only tell you the first step of the way, whereas the guy who said it's going to be 12 grand has walked you through the 12 different steps it's going to take to get you where you want to go, and he says that first step is going to cost $1 grand. They said that first step is going to cost 2,500, and then don't tell you the other 9 steps are going to cost you $25,000. So yeah, you want to really do your due diligence, make sure you're comfortable with anybody you're getting into bed with, and make sure you understand what they're going to be doing for you, what that's going to cost you, what the contingencies are, right? If things go great, how much is it going to cost? What's the worst case, right? If the wheels just fall off, what's it going to cost me to end up with nothing?
I have a quick question. You mentioned the difference between state and federal, depending on settling locales, but we live 8 miles from the state line, and you could sell to somebody in Michigan by accident.
Yeah.
How common is it to actually just get a state copyright or trademark claim for
the value.
Anybody can go to the website and make a purchase, and
yeah.
So if you're like if you can sell to somebody in a different state without even trying really.
Yeah. It's not a punishment type of a situation if you accidentally sell to someone interstate. It's more of a, do you want to avail yourself of this much greater suite of rights and privileges that you're entitled to if you have a federal mark, right? But if you're only going to sell in a 10-mile circle and that happens to clip a little teeny piece of Michigan, it's probably not going to be worth it to get a national trademark, even though you technically could qualify for it because of that little teeny sliver of Michigan you're selling to, right? So the question is what's it going to cost to get that mark, and is it really even worth it to go through that problem? If you're only ever going to sell within 10 miles of your place, then it probably isn't even worth it. But if you do have visions of expanding or selling to some venture capital private equity fund for 10 million bucks and they're going to take it national, then you absolutely would want that national protection, because again, for them, that IP is probably going to be worth more than your entire business, because they plan on scaling it up 100-fold and taking it national. And so your name is going to be far more valuable than the one little machine that they're going to make 100 of when they buy you to mass produce whatever it is you're making.
All right, doing a little segue to copyrights back over here. So copyrights, as we've mentioned, it's like an original expression that's in a fixed, tangible format. So what does that mean? That's kind of examples of our movies, our films, our music videos. So there can be different copyrights within that. The video itself or the choreography within that video is also considered a copyright. And going back to one of the audience questions here, do you need to put kind of the copyright symbol? You should be able to do that just so that you can protect your copyright. So as we mentioned, there's different levels of there's common law that you have, right? So once you create a sort of copyright, you have a copyright, but then there's another level of protection when you federally register that gives you the ability to sue somebody else and also monetary value.
But marking your copyright is very important. If you have a manual, if you develop a website, if you don't put a copyright notice, it will likely be deemed to have been granted to the public sphere. And you will lose your rights in your copyright. So anytime you publish something that's copyrightable, some tangible expression that you've expressed, you'll definitely want to mark that as copyright protected to put the public on notice that no, I'm not giving this away. I'm presenting it to you, but I'm retaining all of the rights in it.
Right, and that could be easily seen as like in books, as you know, with the copyrights, or even on websites, you'll see at the bottom, like copyright, the year that is presented or published, and then the owner's name, whether it's your name or just the entity name. That's a simple way of doing that copyright.
Should that be on your products too?
If for your copyright. So if you're doing like a digital print, for instance, right, you can put your logo on there, you can put the copyright symbol, you can say, copyright 2025 Blue Envy, right? That could be an example, right?
But if you're selling fly swatters, that it wouldn't be construed as something artistic necessarily, right? So you could claim a copyright in it, but when you try to sue someone, the court will probably say, yeah, that's not something that's copyrightable. So if you don't have an attorney telling you what to do, and you want to err on the side of caution, yeah, you can claim copyright in everything you do, and if you've overclaimed, all that means is someone's going to say, yeah, you actually have no rights there. Which is far better than not claiming it and trying to sue someone saying, you once had rights in there, but now you don't.
All right, so these are the different rights that you have when you have a copyright. So the first right is that you're able to reproduce your work. So that means that you're able to create different types of copies of your work. And you're also able to kind of control for derivative works the way that you are able to adapt your original work. So say if you wanted to do another story off of your original story, say you have an original story and you want to do a movie, you have that right to do so, right? The third kind of right that you have is the way that you distribute your works. And so that could be on a website or a streaming platform or something like that. So a direct violation would be if you were at a coffee shop and someone was playing your song, right? That's not the way that you distributed your work. You didn't give them the license to do so. That also kind of bleeds into the way that it's performed or publicly displayed outside. And then, as mentioned, copying an original work from the copyrighted work without permission is copyright infringement. So then fair use, when we get into fair use, that's kind of it's a legal defense that's basically saying that you're able to take a little bit of a small portion of a copyrighted work and turn it into your own. So that's kind of the basic definition of what fair use is. And for instance, fair use can come into different categories, and that could be commentary, critique, teaching purposes, educational purposes, research purposes, parodies. So things that are more like non-commercialized in that way. For instance, like fan fiction, right? You can have an original story and you can write a different story based on loosely those characters, but that could be a really good way of an example of fair use because you're not really profiting off of this fan fiction that you're sending out to people just so that they can read for recreational purposes. So fair use applies when you have these 4 different factors. So you have the purpose and character of the work. So we're asking, if you took someone else's work, did you add something new to it? Did you add a new spin on it, right, to make it your own? So what favors fair use in that case if it's educational purposes? So if you're using someone's transcript or you're using an educational book in a classroom of some sort, you're not going to be copyright infringement, right? Going to the nature of the work used, was that factual? Was it creative? you're really focusing on what's favoring fair use would be just like factual things, not creative works, as we mentioned with books and stuff like that. The amount and substantiality of the portion used, so we're really asking how much of that copyrighted work did you use? So basically, is that a lot? Is that a little bit? And then also as a part of that, obviously, if you're using a little bit, that's favoring fair use versus if you're using a whole portion of the copyrighted work that's not. And then the second part to it is, it's called heart of the work. So if you're taking a big chunk, a big theme of that copyrighted work, that is also into play. So even if you took a little bit of that copyrighted work, but that was the main theme of that work, you're also going to be in violation and you might not be protected under fair use. And the last one is just the economic effect of how much you took from that copyrighted work, right? So if you took that copyrighted work and you're making money off of it, that's not going to be obviously in favor of fair use. So yeah, those are the fair use factors. It's expensive defense, so you don't want to rely on taking someone else's work. You want to try to create everything originally to your own.
So before we go any further into copyrights, it is now officially 7 o'clock Central Time. So if anybody needs to leave, we won't be offended. That said, also the kind of 800-pound gorilla elephant in the room of IP is patents, and we haven't done patents. So if anybody needs to leave the next 5 minutes but wants a very quick synopsis of kind of patent issues, I can do that really quickly now. Otherwise, we can get to it when we get to it in 10 minutes or so.
I wouldn't mind that, actually.
Okay, cool. So yeah, so basically, the upshot of patents is if you are in an industry that is highly technical, then patents can play a critical role in the success of your company and in the success of your company in the sense that it will become marketable to be, acquired by a venture capital firm or something like that in the future. Frequently, though, patents are oversold, shall we say. For example, the, patentmyinvention.com or something like that, where they're promising to help you navigate the process of getting a patent. I would not recommend that process. I think if your invention is worthy of a patent, it's well worth the $12,000 to $15,000 it's going to cost to get that patent. But realize it will cost you at least $12,000 to $15,000 to get a patent.
I thank you for sharing that price range. For anybody in this program, we have an organization that has partnered with us, if you're in this program, and they will file the patent for you only at the cost of the government's charge.
Of the fees.
So,
yeah.
So we do have that.
That's cool. That's great. Yeah, and that would probably be maybe in the hundreds of dollars instead of the thousands or tens of thousands of dollars. Yeah, the filing fees would probably, yeah, it would be about $600. But then going back to the trademark discussion, if you get into a back and forth with the examiner, all of a sudden they start racking up because you have additional fees on top of the original filing fee. But yeah, hopefully it would be under $1,000 to get the patent. If you're working through a program that's providing you
these guys are all former patent office, the people who approve
examiners.
Yeah.
They're former examiners.
Yeah.
That's great. So yeah, that is great. The one thing to think about though is if you are not in a highly technologically intensive area, it may be that trade secrets are the way to go, right? Those are two kind of competing intellectual property tracks to go down, right? And it's a very important decision to make because you can't unring the patent bell once you ring it. The concept between the two is, okay, if you are seeking to protect your intellectual property via trade secret, basically it's free because all you're doing is not telling anyone about what you're doing, right? It doesn't cost you anything to just keep your trap shut.
There's two problems with that.
The danger of that is as soon as you accidentally open your big fat mouth, or as soon as someone reverse engineers it and figures out what you're doing, that cat is out of the bag and you have no more protection, right? Unless they stole it, right? Unless they criminally acquired your secret, you're dead in the water. And even if they criminally stole it, if they stole it and then posted it onto Google, and now 100,000 of your closest friends all know your secret, again, you know, even if it was criminal, they may be subject to penalties, but that doesn't mean that you're gonna somehow get that secret back, right? The secret's only a secret until it's no longer a secret.
So just to make sure, trade secrets have two different prongs to them. You have to, one, satisfy that trade secret provides an economic value by itself. So you have to make sure that it's, you know, producing money, producing revenue of some sort. And then the second prong to that is making sure that, are you maintaining it as a secret? What are some efforts that you're doing to make sure that it stays a secret? Whether that's just the security of where you're storing that trade secret from, or maybe perhaps like a non-disclosure agreement, right? So that could be, if you're working in a company, this is a trade secret, you're signing away to make sure that you're not going to tell anybody. So those are the two things to think about. Does this bring value? Does this have value? And also, what am I doing to protect that value?
So that is one option, right? And again, that one, like the Coke formula, right? You can retain that right and the economic value of that secret for eternity if you're sufficiently protective of that secret. Alternatively, the other track would be the patent track. And it's the exact opposite of a trade secret. Basically, the patent is entering into a deal with the government, where basically the government says, look, we want to advance the sciences, we want to advance technological achievement in this country, and so what will happen is you are going to give us everything you know about this invention. You're going to tell the entire world all of your secrets, you're going to lay all your cards on the table, and in exchange for that, you will have a monopolistic right for some period of time, 15, 20 years, right? And so, as soon as that period expires, now everybody knows all of your secrets and they can compete with you, you know, on a level playing field, because that was the deal you made with the government. You're going to give me and everybody else in this world your secret, and in exchange you'll have a monopoly for 10, 15 years, 15, 20 years, whatever the period is. Sounds great if you can capitalize on that monopoly during those 10, 15, 20 years. Part of that capitalization, though, you know, that's not as simple as it sounds, because, like I said, you've just told the entire world your secret sauce, right? For example, if you're coming up with some sort of hand lotion, you know, some cream that has, you know, some restorative property or whatever. Well, you know, if you keep it as a trade secret, as long as nobody else can figure out your secret sauce, you're going to be able to market your product, again, unthreatened by anyone else. But if you seek a patent and tell the entire world, here is the recipe to my cool eczema cream or whatever, even if you get that patent, that doesn't prevent people to try to work around that patent, right? So if your patent claims, okay, a cup of this, a half a cup of this, 3 tablespoons of this, and a teaspoon of that, somebody's going to say, that looks like a cool product. I'm going to do the exact same thing, but instead of a teaspoon of this, I'm going to do a half teaspoon of this. And you sue them, and they're going to be like, I'm not infringing the patent. If I was infringing the patent, I'd have to do a teaspoon, and I only did a half a teaspoon. And so, again, that's where you need an attorney to think through, okay, how can we draft these claims? You know, how can we claim your invention in a way that minimizes the opportunity for people to get around your patent, so that you can protect that invention? Or, you know, if the secret is that teaspoon is, who knows, the extract of lemon or of grapefruit, you know, and instead of grapefruit, they come in and instead of doing a teaspoon of grapefruit, they do a half teaspoon of lemon and a half teaspoon of orange. You know, again, they're not doing what you claimed, which is grapefruit. They're doing a mixture of lemon and orange. Now, and so again, if you have something that is patentable, that is truly protectable and truly valuable, you know, there are patents that have rung up hundreds of millions of dollars in damages. But for every such patent, there are millions that have never been litigated or have been litigated and were found invalid. And so before you go down the patent track, and I would never go down the patent track via some online thing, because that's a recipe for failure. But before you go down that track, you definitely, again, want to talk to 1, 2, 3 different patent prosecutors and say, here's my idea. What do you think? Is this something that I should really be thinking patent? Or is this something I should be thinking just take the first mover advantage, or just take that trade secret and run with it and make it work for you that way?
So with that being said, here are some of the examples for the copyright cases at least. So the first one really talks about that transformative use is what we talked about, right? So here, basically the individual had already a copyrighted photo of print. The infringer basically took that copyrighted photo and just kind of plastered some color on it, right? They're thinking, oh, this is copyrighted. No, it's not, because they didn't really transform it. It's still the same photo, it's just highlighted in a different way, so that infringer lost. The second case is really fun because this is one where basically the monkey had taken a selfie. Basically a photographer had given a monkey a camera. The monkey had took a selfie, and then the individual decided to copyright that photo. Well, not exactly, because in the Copyright Act, you need a human to have that copyright. So you need to have a human to do it, so they couldn't actually copyright that photo because the monkey took it. So that's also something to think about in terms of like who's actually owning the copyright. And that plays a little bit with AI too, right? Because AI is not a human, it can't protect your work that way.
So even if your work is so simple a monkey can do it,
yeah,
don't let the monkey do it.
And then the last one is just taking a play on different types of copyrights, right? So there's a thing called sound recordings and composition. So that's if you're having a music or you're having a song, there's differences between how the actual song is played out versus the actual composition of it. So there's 2 different types of licensing and types of copyrights that go into that one. Here are some copyright mistakes. So for instance, like even though you might have a common law copyright, it's better to register the copyright early in general so that you can make sure that it's being protected against all others. Using the poor man's copyright, a poor man's copyright is basically saying, you know, I created this copyright, I'm just sending it to myself so that there's proof out there that this is, published, to yourself. Don't do that. Considering what you can and cannot use from other sources, as again, we recommend that you take, that you make your own original expressions of songs or art. And then here's some of the myths that we have too, where it's like, oh, if I use less than 30 or if I use these fewer words, it's not copyrighted. That is not the case. So when to call an attorney, it's basically when you have a copyright and you want to protect it against others. Upon infringement, so if someone's trying to sue you, that's also a time to call us. And then we wanted to highlight this. Copyright registration is actually pretty cheap in terms of the type of application you see. So for instance, you'll see that it's at $45 for one copyright. But also with the copyright registration, under the Copyright Office, there's also different types of applications. So you can file multiple for pretty cheap as well.
So what's the implication if I'm one of the entrepreneurs in the group and I have something that I put that little C with the circle around it, so I put that little copyright next to my thing, but I never applied for a copyright. What's the implication of doing that?
Basically, you just make your life easier if you apply for the copyright. If you have that C, you can sue for damages, but then you have to prove damages. He used this and it caused me X amount of damages. And to do that oftentimes requires a $200,000 investment in a damages expert with a PhD in economics. And so, that's problematic frequently. But if you have registered it with the copyright, there are statutory damages. So now all of a sudden, you don't have to prove the damages, you just have to prove they infringed, and you're automatically entitled to a certain level of damages that are statutorily directed per instance of infringement. So if they've stolen this and used it 50 different times, that's not just one instance of damage, that's potentially 50 instances of damages. So now all of a sudden you can end up with hundreds of thousands or even millions of dollars in damages that you don't even have to prove. You know, it's just, I proved they infringed, give me my money. So that's the type of thing that can really be helpful in registering.
That's very helpful. But if I just put the C there with the circle around it, even though I never applied for copyright, I'm not breaking the law.
No. If you just put your C on a circle and somebody infringes, you can still send them a letter saying you're infringing my copyright. You can still sue them and say, you know, hey, you're
on notice that you're infringing my product. That's kind of the cease and desist letter, essentially.
Yeah. But you have made your life much more difficult. To register it, you need to register it
on the Copyright Office website. So here's kind of the action stage. So we kind of talked about the benefits, right? So if you federally register your copyright, you're getting the benefit of, you know, you can bring an infringement suit against other people who have taken your work. You have the evidence of copyright validity. What that means is, hey, I own this copyright. It's registered within the government. They understand it. You don't have to prove anything else besides just the infringement. And then you're also within a period of time, you will also be, I think it's like 3 months or so, 3 years, that you will have statutory damages, which means that you're able to get this amount of money from the infringer itself. So that's this amount, and then also attorney's fees for whoever is representing you at the time. But for the action stage, it's actually quite simple. If you go to the Copyright Office, even though, you know, we recommend that you go through an attorney because it's a step-by-step process, they do also have tutorial videos, so I'd highly recommend that you check that out.
In terms of level of complexity,
right.
Patents are like way up here, trademarks are kind of here, copyrights are here. If you're going to go it alone, start with a copyright. And because copyrights, you don't have the other side, right? You don't have the attorney representing the government saying, I don't think you're doing this right. Basically, you just have to make sure you fill out the form accurately and put your copyrighted material on file with the Library of Congress, and you're done. It's very hard to mess this one up if you are reading those FAQ tutorial type aids that are plentiful on the copyright website. So yeah, if you're gonna try to go it alone, this is the one to do it with. Or, you know, hire an attorney for the first one so you can see a pro do it, and then for the rest of your life, you can basically just mimic what they've done.
So kind of going back to that action stage here, so if you're thinking about doing the copyright, you can go to the Copyright Office. Again, they'll walk you step by step, or also there's tutorial videos. But here's some of the things to think about when you're first doing the application. Depending on what type of work it is, they're going to have different applications. Are you trying to file for, you know, a graphic design? Are you trying to do it for a music video or a film? They're going to have different fields of what you need to complete. And then here's some questions to think about. Is this a work made for hire? So that kind of goes as to, do I own it, or does someone else own it, or a third party own it? Is this work unpublished or published? So did you present it out to the public already? Is it, or are you keeping it to yourself? What kind of application do I need? So I said there's different types of applications depending on what you want to copyright, and then how much does it cost, and they'll show you that on the website too. Like if you're only filing for one type of copyright, it was a 45. If you're doing multiple, it might be 85 or above 100.
And I will say, even though I say copyrights are the most simplistic of the three, that doesn't mean it's not without risk when you do it on your own. Sorry to be the attorney and try to scare you all. But, for example, she said, you know, certain types of works you can register as a compilation, right? So if you're doing it on your own, and you're doing 30 different things for 45 bucks a pop, and an attorney could have said, you can lump all these 30 things together and do it for one fee of 150, now all of a sudden the attorney paid for himself by allowing you to register in a cheaper manner than you might have known to do on your own. Or, you know, if you do screw it up and click the wrong button, it could invalidate your copyright, and then when you try to sue somebody, you realize, dang, now I'm out those statutory damages of, $750,000 to $300,000. So in terms of relative ease, these are definitely the easiest, but that said, it's still legal work.
You also have to pay attention. Sometimes they're very specific as to how you present your work, whether it's like a specific type of PDF file or some sort of video format. They're also going to make sure that you need to upload it correctly. So that's where you can go wrong if you're doing multiple, right? If you fail to upload one in the specific that they want, they might reject it. So that's something to consider as well. So here's some business typos that we kind of came across. So for instance, can you copyright a dance routine? The answer here is if it's a common dance routine like the ones that you learned in school, no, you cannot because they're already publicly used and there's not really any original expression to it. But if you have a dance that's fixed, it's tangible, perhaps someone is making up a specific dance. For instance, like I don't know if you guys have heard of Fortnite. There's a Fortnite dance going around. That's very specific, very customized. That one can be protected.
So is the Trump dance copyrighted?
He probably could copyright it. I don't know if he has.
And then the next business type we have, which we kind of a little bit talked about with the trade secret aspect, is can you copyright recipes as copyrights? And then also can you do it as a trade secret as well? So we want to caution for copyrights for recipes. If it's just a laundry list of ingredients, you can't do that, right? You can't protect it as a copyright because it's factual information, really. It's not anything that's being original. You're not really creating anything to it. It's just a laundry list. Anybody can use it. But on the flip side of that, you can copyright it if you're making a recipe book because maybe you're adding instructions. Oh, like mix the eggs or whisk the eggs at a certain time, or like set the temperature at this, and then the reason why I did it is because of X, Y, and Z. So if you're adding examples, if you're adding stories, that's why you'll see a lot of celebrity chefs adding stories as to why the dish is made a certain way, or maybe the history about the dish. Those parts can be copyrighted as part of the recipe. And then in terms of trade secrets, we talked a little bit about that. You can have recipes as trade secrets just like Coca-Cola. You just need to make sure you have economic value and you're having ways to protect that recipe. All right.
Awesome. So we'll quickly go through this. We already talked about patents. So if anybody has further questions on patents, type up, chime in, but I think we've kind of covered that. Protecting your name. How should owners protect their business upon receiving negative comments or reviews? Okay, so this one can be tricky, right? Because if you have someone who's getting after you on Yelp or something like that, frequently there is little that can be done. That said, if what they're saying is provably false, then all of a sudden you definitely have something to work with, right? You can sue them for libel or slander or defamation or tortious interference. If they're just posting their opinion though, I think this product is crap. It's going to be very, very difficult to get that taken down. That said, maybe you can, go to Yelp, go to Amazon, go to the policies that describe the way that they treat reviews, right? Maybe it is a situation where to post, they have to have purchased your product and you can prove that this person has never purchased your product, right? Or if they have posted, maybe there's some sort of mechanism where you can post a reply underneath it to, give your side of the story, right? That type of a thing. So frequently there's not a lot to do. That's one reason when you buy things on Amazon or whatever, frequently there will be some sort of, coupon that says, hey, if you leave a review, you can get 25% off your next purchase or whatever, because they want to drown out those negative reviews, right? And so this is actually a difficult one. But the first thing to ask if you have negative reviews is what they're saying a matter of opinion? Everybody's entitled to their opinion. Or is what they're saying an assertion of fact that you can prove is false? If that's the case, that changes the entire complexion of the situation, right? And that's when you want to think about getting an attorney involved and sending a cease and desist letter and, start pushing back against these negative reviews that are providing false information about your product or about your company. Quickly about AI. So I think everybody knows how it works. It's, you know, these large language models. AI really doesn't do anything from scratch, right? And so what it does is it takes from the entire universe of information and tries to synthesize based on that and based on your prompt what it thinks the answer to your question is. The problem with that is when you ask AI to make you something, it's not creating it from scratch, right? It's borrowing from all of these different places. And what it's borrowing may be completely legitimate, or it may be copyrighted information, right? So if you ask it a question and it, you know, how do I do this? It's possible that it pulled that from some copyrighted book or some copyrighted article. And so if you're using AI straight out of the box, you have a high risk of getting yourself into trouble if you don't properly vet and control for those concerns, both yourself and your third parties, right? If you hire a web developer and they used AI to develop your website, you may not have had anything to do with it, but if you contracted with that person and they did it, you're the person who owns the website, you're the person that person who got stolen from is going to come after, right? And so that's something to think about if you're hiring someone to build a website for you, if you're hiring someone to develop, you know, a manual to explain your product or something like that. It's worth thinking about, do I need to talk to whoever it is that's doing this to confirm that they're not using AI in this process, or if they are, they're indemnifying you against any risk associated with that use, or they, you know, properly vetted it to make sure they're not violating any sort of rights in their use. Trademarks in AI cases. So there are a lot of new cases. There aren't a ton of AI cases that have been all the way through to decision, but there are a lot of interesting cases that are in process. One of them, for example, is a case that the New York Times brought against OpenAI. Basically, and this is common in a lot of industries and has been particularly troublesome in the legal area, where people have asked the AI to draft a brief for them or draft a report for them or something. And AI does what it does, and it says, okay, when, you know, someone has responded to this type of question, they've always put some sort of support behind this assertion. So I'm going to put some support behind this assertion. And they said, you know, so-and-so and so-and-so did this and this and this. Cite to New York Times article from 1987 titled this and this and this. You go back to 1987 and no such article ever exists. Because AI knew that the appropriate thing to do was to have factual assertions be supported by evidence, and so it posted evidence. It's just that that evidence is fictional, which is particularly troublesome when your associate does that in a brief and the judge catches you, and then you catch all sorts of problems. So that's one type of problem you can get into when you're using AI, but you're not doing your own diligence to make sure it's being used properly. Another one, Getty Images. Basically, again, AI was gathering pictures, and they're like, hey, when I see pictures, they have this weird watermark on the bottom right corner of it or something. So I say, hey, make me an image of a soccer player, and it makes me an image, and then it says all these other images have a Getty watermark on it. I'll put one here too. And so now all of a sudden you have this AI-made image with a soccer player with a gimpy leg and a sixth finger, because AI is not perfect, and it has a Getty watermark on it, and Getty's like, no, that garbage is not ours. And so again, you know, those are the type of concerns that you need to kind of look out for in AI. AI, I think the upshot for AI is that you rarely are entitled to the legal upside for what you create using AI, but you are almost always liable for any legal downside associated with your use of AI. So, for example, if you create something with AI, if you create a picture with AI, it's going to be very, very, very difficult for you to get rights in that picture because, again, going back to the monkey taking a selfie, the copyright office is going to say, you didn't make that, AI made that. So even if you put in a super complicated script to explain to AI exactly what type of picture you want, the AI is what made the picture, so you're probably not going to get any rights in it. On the flip side, again, if you use AI and it creates something like that Getty image, you are going to be on the hook for that. You can't say, it's not my problem, that was AI that did it, right? You can't claim what it does, but you can definitely have its faults attributed to you. So that's the risks profile of an AI. You had a question?
Plus, more of a statement. I go the route more of like top secret. So if I do my website, I would have all my own original stuff written and everything. Only internally would I use AI, and I would use it in very minuscule. That's just how I would have to do it.
It could be a really great starting place. Like for instance, if you're trying to come up with ideas with your logo or a slogan, you can try to type these prompts in and you can try to get some ideas and maybe that gets the flow going. But it's not advisable to just take it exactly. As what Bree had mentioned, it could just be a gathering of other people's copyrights and just acclimate it into that result, right?
So externally is always me.
Yeah.
Smart.
Exactly.
Exactly.
And then whatever.
Yeah.
Right.
That's a smart
So I use AI just a lot in general, but for my business particularly, I make custom gifts and graphic design, but I always enhance it. I never use it like at face value. But I thought like with Midjourney specifically, with the package that I have, that the rights are mine. So should I not be using AI for images?
So that, like I said, is an unresolved issue, right? There are a lot of cases kind of in that vein.
It depends, I guess, so for instance, if you're creating something on Midjourney and you have that image and say like you are adding things to it, right? The additions that you're adding are protectable because those are the things that you're making, but not the underlying image. So there are certain cases like that where comic book designers are also kind of trying to create, AI-generated comics through those types of works of art. If they tweak it, again, that's what they can protect, but you can't protect the thing that AI made. Does that make sense?
And it's only those tweaks that you can make, right? You can't create a 30 or 300 page, fictional pictorial novel or comic book and make 3 little tweaks here, do some shading here, do some shading here, do some shading here, and boom.
Right.
Now the entire 300 page volume is yours. The courts are going to say, you get that little shading here, and that little shading here, and that little shading here. Everything else is public.
And even for the text prompt, right? Even though if you're the ones that are kind of generating the ideas, if AI is doing a lot of the writing and heavy lifting, that isn't protected.
Which is why, again, it makes sense to, use it internally, right? Use it to generate ideas. Use it to come up with what you think is the right thing to do, and then do it in your own language, do it in your own hand, and recreate it using your own.
Don't play
this. Of it, but still make it your own.
Exactly. Exactly. So yeah, we'll quickly hit rights publicity, and then we'll be done.
Yeah. So this is basically just making sure that you know what rights publicity is. It's the legal right of individuals to kind of control their name, image, and likeness. And basically what we want to say is just be careful when you're advertising your business. If you're going to try to use some sort of celebrity, you want to make sure you know that right of publicity, that they have one. And it's discouraged to kind of use AI in that way to portray someone else representing or supporting your business in that way if you don't have their permission. So that's kind of one of the biggest takeaways from this slide is try to create things that are original. If you have that license or that permission to get somebody to help promote your business, then make sure you have it in writing, make sure that you are speaking to them, but don't go that route where you're using someone's fake voice or you're using someone's name to say, oh, they support my product 100% or something like that. Here's some of the advertising AI cases that we had kind of mentioned a little bit earlier. For instance, like as we said, if someone's using a stand-up comedian voice, that's not okay. Or someone using kind of a deep app, fake app, where they're using a celebrity to kind of promote their business, that's also not okay. So here's some of the remaining AI questions. We kind of had already touched upon it in addition to what we had talked about earlier about how, what do you do when you have photos of employees on your website? Can you use that? So for AI, generally speaking, you can only protect the things that you have original expression over versus right publicity. Can you use the photos of the customers or employees on your website? We would highly recommend that you get written consent from your employees, and that could just be a form that says, I'm using your photos for X, Y, and Z. This is how long we're using the photos for and the reasons why you're using the photos to do so. And I think we go into the last thing. We talked a little bit about resources already with the bar associations, with the clinics, with pro bono programs. But then there's also, firms also have websites that have resource pages on them, so you're free to take a look. Ours is an example of this, where we have IP resources from trade secrets, patents, copyrights, trademarks, and you can go and look at them because they'll have different guides for different types of cases that we offer too. So I think that's the end of our presentation. If you have any questions, we're happy to stick around, answer them, or you're free to email us as well. So thank you so much for being here.
Thank you.